So last class we had completed the topic consideration, meaning, definition, the essentials of consideration and exceptions to consideration. So our next big essential for a contract is capacity of parties. If you remember, we had discussed three major conditions for a person to enter into the contract. What is the three basic conditions, right? That he must not be a minor, he must not be a person of unsound mind, and he must not be a person who is disqualified by any law. So let's look at the topic capacity of parties in detail. Definition. So the Indian Contract Act, according to Section 10, defines all agreements are contract if they are made by the free consent of the parties competent to contract. So it says agreements, yes, they are a contract only provided that the parties entering into the contract are competent. Now, what is the word competent meaning or capacity? As per section 11, the Act defines persons who are not capable to enter into a contract. So, first we need to know who are those people who cannot enter into the contract. So, apart from these people, anybody else can enter into the contract. So, what does Act say about those people who cannot enter into the contract? Three kinds. One, he must not be a minor. Second, the person must not be mentally unsound. Third, persons disqualified by any other law. That means they have a criminal record upon them, etc. They have been insolvent, or they have been already cheated different people in the different circumstances or contracts, and now therefore he cannot enter into any other further legal contracts. Persons of unsound mind means they are mentally unstable in order to make a decision for themselves. What is right, what is wrong, they are not in a mental state to decide for themselves. Therefore, you cannot enter into the contract with persons who are unsound mind. And minor. Now, minor is what each of these characteristics that we have provided here, right? Minor, unsound, and disqualified. Each of this in separate detail we'll study, starting with minor. Who is a minor? A minor is a person who has not attained the age of majority. So, our Indian constitution says who is a major? Person who has attained the age of 18 and above. So, any child or student maybe who is under 18 is not allowed to enter into the contract. Is that clear? So, that is the meaning of minor. There are certain rules and regulations, or let's say conditions laid down by the law in terms of minor entering into a contract. So, today we are going to look into that. Rules of minor under the law. First point, an agreement with a minor is void. Entering a contract with a minor is void ab initio, that is void right from the beginning, because minor is not competent. So, minor or children under age of 18 are not able to take their own decisions mentally. Again, they don't know what is right or wrong, or to make certain choices or decisions for themselves. There will be parents or guardians taking decisions on behalf of them or for them. But children or individuals under 18 on their own cannot enter into any kind of legal capacities or any kind of legal agreements because they are not competent. So, therefore, what does the law says? An agreement with a minor is void. Void means it is not enforceable by law. So, in case you are a major, but you are entering a contract with the minor. So, from the point that you are entering, it is void. That is called as void ab initio. Initio means what? Initial, initiating. So, right from the time you are initiating the agreement with a minor, it is void in the eyes of law. So, that's the first rule. Second, minor can be promisee or beneficiary. See, you cannot ask a minor to pay bills, right, or to pay some legal duties. But then, can he be a receiving person? Can he receive certain benefit? Can he receive certain promises? Yes. Law says, yes, he can be a promisee or a beneficiary. Minor can be a beneficiary or a promisee, and there is no restriction being a promisee or a beneficiary. Now law says he cannot enter into a contract where he has to perform certain activity or make certain decisions. But if you are making a contract with like for example say through a trust, okay, that minor, so I'm transferring my entire property in a form of a will for my child who is below 18 years, okay, so then that agreement is valid in the eyes of law. Because why? Is the minor performing anything? No. Is the minor has supposed to pay anything? No. He is just enjoying the will or enjoying the property that I've written for him or for her. Okay. So he's just getting the benefit of the will. Okay. I have promised to write my will or enjoy all my property to my child of him or her. So he is only the beneficiary of the will and not any terms of legal formalities. Is that clear? So second point is minor can be a promisee or beneficiary. Next, third point, no ratification and to minors agreement cannot be ratified by him on attaining the age of majority. Now, first of all, ratification means what? Changes. Okay, you are altering the agreement or you are changing the agreement. Now, it says no ratification. Law says no ratification. That means you cannot alter. What can't you alter? That is, the minor's agreement cannot be ratified by him on attaining the age of majority. For an example, let's say a child who is below 18 has entered into an agreement. Okay, now because he is a minor, that agreement is not enforceable by law. So once what he attains the age of 18, under the law he becomes a major, correct? He becomes a major. Now can he change the same agreement which was void before? No. The law says no. What was initially you entered into the agreement when you were a minor, it is a void agreement. Now just because you have entered into you have become a major or you have entered into the age of 18, you cannot go back and alter the agreement or alter the contract, because in the first case the agreement was void in the eyes of law or unenforceable in the eyes of law. What is void in the eyes of law? How can you alter or change the conditions of the agreement? So that is not allowed, is what the law says. No ratification to a minor's agreement on him attaining the majority. Point 4. Minor's liability for necessaries. Minor need not hold any specific performance here. Minor's liability for necessities means to say that any basic necessities. Now you're providing him shelter or you're providing him food, water, shelter, any basic necessities of life, yes, you can provide to him, but then he's not liable to pay for that because he's a minor under 18. For basic necessities, yes, he has a right to receive the necessities of life for a living. If the minor is on the verge of death or in the verge of death and life, if you're providing him in food, water, shelter or clothing, yes, that is enforceable by law. You cannot stop him for the necessities. Now just because I provided him food, shelter, I cannot ask the minor to pay for that. Is that clear? That is what it says, minor's liability. Liability means what? Something that you need to pay. That does not have to happen in the case of minor. You provided him food and shelter, you cannot demand money from him. You cannot ask him for to pay for the necessities that you have provided to the minor. Number 5, minor cannot be insolvent. That is, minor is incapable of contracting debts and dues are payable from the personal properties of minor, and he is not personally liable. As we have said earlier, minor can only be a beneficiary or promisee. He can only receive things from the other person, but he can never be made liable or he cannot be made insolvent. Can he purchase a debenture instrument or can he purchase any other things into a legal capacity? No. Minor is incapable of contracting debts and dues. Debt and dues means what? Something that he is responsible for payment. Even though he might have big properties in his name, but then you cannot ask him to pay until he is a major. He cannot be insolvent because he is not personally liable until he has attained the age of 18. Point 6. Joint contract by minor and adult. In this case of joint contract, the adult will have to take responsibility for contract and not a minor. Now let's say a person who has attained the age of majority, that is, let's say a person of 20 years and a person of 12 years, okay, has entered into a contract to buy to purchase certain raw materials from a supplier. Now what happens, this joint contract, or these two people have taken the goods from the people or from the supplier but have failed to make the payment. Now how is the person liable here? Now the supplier, can he sue both of them because they are in a joint contract? No, he cannot involve the minor here. He can only involve or go legal against only the adult here who has crossed the age of 18. Only he can catch hold of the adult of the non-payment of the price but not the minor. Therefore, in a joint contract, no matter what default the contract has, only the adult will take in charge of the dues or payment. No legal or filing of case or anything can be taken action against the minor. Point 7. Minor cannot be partner. Now all of you have learned this chapter, right, in your PUC partnership accounts, right? There you have heard retirement of a partner, admission of a partner, death of a partner, correct? Now there in the topic called admission of a partner, hope you've come across admission of a minor, right? A minor being incompetent to enter into contract cannot enter into partnership agreement. Notice that word, cannot enter into partnership agreement unless agreed by all the partners. Now notice here, because he is incompetent or incapable by law, he cannot enter into agreement. Minor cannot enter into partnership agreement. Now how is this partnership coming into existence legally? By an agreement. Now first thing what we learned is what? An agreement with a minor is void, correct? That was the first rule we studied under the law. Now let's say we are a partnership firm and we want to make a minor a part of our firm. Is that possible? No. Legally it's not possible. Now it is, let's say one of the partners has died and their child who is a minor. Can you make him a partner in place of his father? Yes, only provided all the other partners agree. And there's a second condition. One condition is that all the partners agree to it. Second condition is that only if the partnership firm earns profit, the minor will get a share. But if the partnership firm, because partnership firm's liability is unlimited, correct? It's not limited, it is unlimited liability. If the partnership firm faces loss, then the minor has no right to make any kind of payment or make any kind of liability on his head or on his responsibility. So minor can be only enjoying the profits of the partnership firm until he attains the age of 18. But then until he attains the age of 18, he cannot be made liable for any kind of dues that has the partnership firm has to pay. Only the other partners have to take care if there is a loss or there is a liability, etc. But minor cannot take up the responsibility of liabilities of partnership firm. But if there is profit, yes, he gets the equal or the agreed share of profit in his name. Point number 8, minor and his position of his parents. No liability has been imposed on the parent even if the contracts are of necessaries. Now if somebody is providing for a minor, You cannot go ask, if the minor has entered into any kind of legal agreement, and then because the minor cannot pay legally, you cannot go and question the parents. Is that clear? Parents cannot be held responsible for minors entering into a agreement. But can parents enter into some agreements on behalf of their children when they are minors? Yes. For an example, opening bank accounts or taking insurance policy for their children. Is that valid in the eyes of law? Absolutely yes. Now, even before you have attained the age of 18, your parents would have definitely opened a savings account or a fixed deposit account, or even taken a LIC policy on your name. Now, that time is those agreements invalid or void in the eyes of law? No. Parents, on behalf of their own children, can take certain legal documents or legal formalities for their children, such as an example, opening bank accounts and insurance policies. Ninth point, minor cannot be a surety. As minor is considered as incapable person for contracting transaction, he cannot act as surety. He is not liable to pay. Now, if two people are entering into contract, but for a consideration to stand as a guarantee, we need a third person to stand as a surety or a guarantee. Now, when two people are entering into an agreement, you cannot take a minor's name as a part of surety or a guarantee. Minor can never be a surety or a guarantee because he himself is incapable of entering into any kind of transactions or payment. Why do you keep a person as a surety? Reason being, in case you make to in case you fail to make the payment of consideration on behalf of you, the surety, whoever the person is standing in the place of surety, will have to pay on behalf of you. Now, if you keep a minor in the place of surety, will he be paying? Will he be liable to pay in the court of law? No. He is incapable and incompetent, so you cannot take a name of a minor in the place of surety. So, minor cannot be a surety. Last point, no restitution. Restitution refers to resorting of a thing to its proper owner. What does restitution means? Resorting of a thing to its proper owner. A minor need not be compensated for the benefit obtained. As we just said earlier, right? He cannot be held liable for the necessities that you have provided for him. You have provided clothing, food, shelter, and you cannot ask him to pay because it is necessity. Let's look at the conditions here. The doctrine of restitution includes the key points. First, one party has entered into a contract with another for consideration. Thereafter, one party failed to perform his part of the contract, or the contract became void due to any unforeseen condition. Now, the party which paid any consideration as advance is entitled to recover. Notice that word, entitled to recover the same from the other party, and the other party is not entitled to receive an unfair advantage over it. Now, here what happens? Let's say A and B has entered into a contract. Okay, and here uh, A is made some conditions to an agreement to purchase or sell certain asset or supplies or necessities, anything. Now, for some unforeseen conditions, A priorly, by the time is entering into the contract itself, has paid some advance, but both the parties were not able to complete or complete it legally, the agreement, because of unforeseen conditions. Okay, unforeseen conditions. Now, here what happens is that now no restitution means, now if that one party is a minor, you cannot ask him to pay back the necessities, whatever necessities you have taken from me. Now, since the agreement has become uh, incapable of performing due to unforeseen circumstances or conditions, you cannot ask him to pay back whatever he has received. This is only in the case of minor. Remember that no restitution means something that you need to give back what you have taken, entitled to recover. You cannot ask the minor whatever benefit is received, or the money he has received, or the benefit he has received, because the agreement was not enforceable or completed. You cannot force him to take it back or give it back from the take it back from the minor. Is that clear? So that is the last point. No restitution means a minor need not be compensated for the benefit obtained. So if he has obtained any benefit, you cannot ask him to give it back or pay for the benefit he has received. So these are the 10 different rules that is laid down by the law for a minor. So we studied what is the definition of a minor, who is a minor, the rules of a minor under the law. An agreement with a minor is void. Minor can be a promisee or beneficiary. No ratification to a minor's agreement. Minor's liability for necessities. Minor cannot be insolvent. Joint contract by minor and adult. Minor cannot be partner. Minor and his position of his parents. Minor cannot be surety, and no restitution.